is a community education production brought to you by the Bar Association of Montgomery County and the Montgomery County, Maryland Bar Foundation. The program is designed to provide you with general information regarding your rights and obligations under the law. It is not intended as specific legal advice. You should discuss the facts and circumstances of any particular matter with your own attorney and obtain advice specific to your case. The participants are local attorneys who have volunteered their time to bring you this program. We hope you find it informative and beneficial.
Welcome to Law School for the Public. My name is Mark Gilday, and I'm a partner in the law firm of Bregman, Burbert, Schwartz, and Gilday, located in Bethesda, Maryland. Our show today is called Online Defamation. While defamation has been around for many years, the problem with defamation has intensified with the use of the internet as a reporting and social tool. In fact, social networking has created a number of interesting legal issues. One of these issues has to do with defamation laws, and many individuals, businesses, and website owners have the mistaken belief that they are free to say whatever they want on the internet, and that is not true. Indeed, online defamation is the publication of defamatory statements made on any internet-based media, including websites, blogs, and even social networking websites. And if you participate in online defamation, you may find yourself in trouble. Here to discuss online defamation this evening are David Watkin and Mark Balin. David is an attorney with the law offices of David S. Watkin, located in Potomac, Maryland. His experience as an attorney spans a wide range of substantive issues, including matters involving defamation, privacy, social media, and the internet. While he is a guest on the show today, he has served as one of the hosts of this show for many years. Mark Balin is a partner in the law firm of Baker Hostetler in its Washington, D.C. office. As media and technology have evolved, Mark has transitioned from representing traditional media outlets to also representing clients in the growing fields of the internet and digital media. He represents websites, bloggers, and others who publish and disseminate news, information, and opinions. David, Mark, thank you for joining us. And if I could start with just the first basic question, if you could give us a basic definition, David, of defamation.
Defamation, first of all, thanks for having us. Defamation is the false publication of factual information that hurts your reputation. It's defamatory, causes people to think less of you, and it causes injury.
With respect to the publication, can you explain briefly what you mean by published?
Well, published is probably more of an archaic word nowadays, but really disseminated is probably the best word. That it goes to a third person. So you can't defame yourself to yourself. You can't, if you send a letter to me saying something defamatory, that would not be defamation, actionable defamation, because kind of the nub of it is your reputation being injured, and your reputation is how other people perceive you. So it has to go to at least one third party.
And that's a good point about it. It just has to be one. A lot of people think that when something is published, it means it has to go to thousands of people or hundreds of people or millions of people. It doesn't. Just one person, so one extra person, that can be an actionable claim for defamation.
So if I were to say something defamatory about David just to you, that could qualify as defamation?
That would qualify as defamation. And if you said the same thing to David without anyone around, he would not have a claim against you.
And what about just generally harm? When you refer to, Mark, David referred to a harm, what sort of harm has to occur to this person who's been defamed in order to have a claim for defamation?
Well, that's an interesting point. The Supreme Court actually addressed this in a case, 1973, the Gertz opinion, where they said there has to be some actual injury to the plaintiff. And the injury could be economic, such as that their business went down or in their trade or profession, but it doesn't have to be. It could also just be that someone in the community thinks less of you, and that is considered actual injury.
And how would you prove that somebody in the community thinks less of you?
You would do just that. You would have people come and at the trial, and they'd come onto the stand, and they would testify that they thought this was your reputation before the defamation occurred, and now this is what they think of you after.
Now,
Mark, let me just
Yeah, go
interrupt on
ahead.
that. But there are certain types of statements that are considered per se defamation, saying something false that injures someone in their trade or business, as an example, that accuses them of a crime, for example. Those are things that the law basically recognizes. Saying something false about someone in those categories are going to be considered to hurt your reputation, and it's ultimately going to be a jury question to decide since the main remedy for defamation is damages, money, how much that injury caused in terms of damage.
Now,
And money.
We are talking about the term defamation, but we also hear the terms libel and slander. Can you explain to us, Mark, what is the difference between those three terms as people bandy them about?
Right. Well, historically, libel was meant to mean the written word, something that was written down, whereas slander was the spoken word. And a long time ago, the distinction was more important about that, because the spoken word usually would not be, there was no recording devices, there was no television, there's no radio, and so the spoken word would be said, and then that would be the end of it, essentially. It'd have to be repeated by someone else in order for it to be heard again. Whereas the written word was thought to be more damaging because it was written down and could be seen by many people in many places. So the law treated them differently. As technology and the law developed, though, they basically, for the most part, have merged. And so libel is essentially the written word, and also on television and in recordings, you can be libeled as well. And defamation really just covers the gambit of both
So
slander
defamation
and
is the
libel.
category, if you will, and libel and slander are both subsets.
I would say for practical purposes, the law is basically the same, and so defamation is a good catch-all term to
Okay.
use to describe libel and slander.
And so when we talk about online defamation, we are, in that instance, it is written, or I guess it could also be oral, correct? It could be a recording on an online, a YouTube or
video.
something like
Videos,
that.
absolutely.
And when we talk about online defamation, what are we actually talking about? We know defamation in the old days, if you will, would be something written in the newspaper or a magazine. Now we have this new category called online defamation. What is online defamation?
Well, it could be on a website, it could be on a review site such as TripAdvisor or Yelp or Angie's List. There are lots of websites nowadays where you can write comments. For example, on the Washington Post website, there's, as in many newspapers, have a comment section below their articles. People can post things there. It's basically any written statement could potentially be defamatory if it meets the test for defamation.
So online defamation is simply defamation that is posted
That's on the internet.
in some media form on the internet.
Right.
And so what is the difference between defamation in a newspaper, let's say, and defamation online? Or is there any difference? Are there different protections? Are there different requirements? Mark?
Okay, go ahead.
Well, there are. I mean, the big one is a statute that Congress passed in 1996, I believe, the Section 230 of the Communications Decency Act. And the law that Congress made was essentially gave protections to the website operators, to the internet service providers, such as Comcast or Fios, that provided the lines, but also to websites that operate, their operators of websites such as Google and Facebook. And it said that you would not be responsible for what other people post on your website. And that gives them essentially an immunity, so that if there's anything that's defamatory that's posted, they cannot be liable. That's not true in a newspaper. The
Right.
newspaper can be liable even if someone writes a letter to the editor, and that's someone else's writing. But if they publish it in their newspaper, the newspaper would be responsible.
Yeah,
So-
I mean, a good example is, as a general rule for defamation, if somebody says something defamatory, they can be liable. But if someone republishes you write something defamatory and I print it in my newspaper, even though I was not the one who wrote it, I could be liable. The difference with online defamation, with the statute that Mark was talking about, is Congress created an exception. So you write a letter to the Washington Post and they print it in the paper and it's false and defamatory, both you and the paper can be liable. If instead of writing a letter to the Post, you write a comment on their website, well, you could still be liable, but the Post would be immunized from liability under this Section 230 that Mark was talking about.
All right, so there's a clear distinction between the old newspaper, if you will, and the letters to the editor, and let's say a Washington Post article where you have a comment section underneath it. And if you read the comment sections, oftentimes you will see people posting comments on the article, and then they'll start going after each other. And in that instance, if one person writes something defamatory about the other commenter, the Washington Post is not liable for that. That's what this Section 230 protects against?
Yes.
Yeah, in essence. And the idea behind it is Congress wanted to help promote free discussion and communication on the internet. And because there's so much of that commenting going on and back and forth, and it's happened so quickly, if they didn't have that protection, I think Congress realized, and that people in general realized, that if the Washington Post was going to be responsible for all that, they would have to review it, and there wouldn't be that kind of free-flowing communication.
And is the idea then, if I have letters to the editor, there's more time to review the letters and decide what to actually publish in the newspaper?
That's part of it, except I think the exception, that's the rule. The exception is the protection for the online forum operators. So like the Washington Post comment section, Yelp, TripAdvisor, OpenTable, people who are posting comments there, as long as those website operators are not actively involved in the content creation themselves, then they're going to be immunized. The people who wrote the comments could still be responsible. Yeah.
Well, let's talk about some examples that maybe people may have experienced or they might be able to relate to. Let's say I go to a restaurant. I realize that I know the owner and I haven't liked the owner my whole life. So I go home and I go onto Yelp to review the restaurant, and I say, I was at the restaurant, it's a lousy restaurant, and the owner is selling drugs out of the kitchen. And I post that on Yelp, all right? Now, the owner of the restaurant comes to you, David, and says, what can I do about that? All right? Assume that I am not, as the owner, selling drugs out of my kitchen. All right? So he comes to you and says, what can I do? Practically and legally, what can I do?
Well, the part about selling drugs out of the kitchen, assuming that's false, like you're saying, that is clear defamation, and because it's false and defamatory, injures his reputation, and it probably was published, with the requisite degree of fault, which is probably at least negligence. Maybe he knew, in your hypothetical, the person knew they were writing false information.
Correct.
So it's actionable. They're kind of there's the practical side and there's the legal side. On the practical side, obviously, you don't want to go suing everybody who writes a negative review about your restaurant, and people are entitled to their opinion. But when it crosses over the line into accusing someone of committing criminal offenses, you could take action in terms of, assuming you knew who the poster was, you could send them a cease and desist letter. A lot of times you don't because it's anonymous. You could go to Yelp and try to get them to take it down. But short of those things working, then you would have a lawsuit for defamation against that person.
And then you bring that lawsuit against the poster who you know because it was not anonymous, and that poster comes to you, Mark, and says, I've now been sued for posting this on Yelp. What can you do for me?
Yeah. Well, the first thing I would do is we would look at what was actually stated. And what did you write in the review? And I think in your example, you said the restaurant's lousy. I went to the restaurant and it was lousy, and also the owner's selling drugs in the kitchen. Well, as David pointed out, the issue with respect to selling drugs in the kitchen, that's a statement of fact. Either you sold the drugs or you didn't. It can be proven true or it can be proven false. And that's basically the test as to whether it's opinion or not. Is it a verifiable statement of fact? The other statement about the restaurant being lousy, That's not very easy to prove one way or the other. It's really a subjective viewpoint or perspective on what the quality of the restaurant is. And that would traditionally fall under what's opinion, and that would be protected.
Protected, why?
Well, because basically it's not a false statement of fact. And to be defamatory, as we were talking before about what are the elements of defamation, one is it's got to be a false statement of fact. It's got to be a statement of fact. It can't be a figurative language or hyperbolic. It's got to be an actual statement of fact, not opinion. And in this case, I think it's pretty clearly saying that the restaurant is lousy is opinion. The statement about selling the drugs is going to be a little more difficult. And for that, you would have to talk to the client about essentially what is the basis for their making that statement. And then you might look at it and say, well, was it said in how was it? What's the context? Context is very important in defamation.
Let's assume it's a nightclub, okay? It's a nightclub. It's not a five-star restaurant in a nice part of town, but it's a nightclub where there's all kinds of things going on in there. Would that make a difference?
Well, when I was referring to context, I was referring to the context of the publication.
Right.
But to the extent that if it's a restaurant or a nightclub, and the fact that there actually might be drugs at that nightclub, and if there was proof that drugs were being sold at the nightclub, but you got it wrong that the owner was selling them and it was someone else who was selling them, that might be helpful in defending a libel case, because again, it only needs to be substantially true. What you're saying. And if the gist or sting of the publication is true, that drugs were being sold in the nightclub, and that's true, even if the owner didn't himself sell them, you might be able to convince a judge that this is substantially true. So there's a whole litany of defenses. What this really goes to is the fact that defamation law is in some ways stacked against the plaintiff, the party bringing the suit. Mm-hmm. The First Amendment provides a number of defenses, a number of ways for a party who is being threatened with libel or defamation to try to get out of the suit, whether it be by saying that it's not a statement of fact, a false statement of fact, by saying that it's a opinion, it's hyperbolic language, and then they don't have that you didn't make the statement knowing that it was false if it's a public official, or in some states, not Maryland, but in other states, they'll recognize that if it's just a matter of public concern, you can have that additional protection.
So you touched on something. What if I posted this and I thought it was true?
Well, it depends then on the status of the plaintiff, the party bringing the claim.
Right.
And
it's a private party. It's not a public figure.
Okay, so we have public and private figures. A private party, and David alluded to this as the requisite degree of fault, as when he said before, the typical standard in most states, including Maryland, is negligence. So even if you thought that was the case, if you should have known that that wasn't the case, then you could be found to have been negligent.
And
if you didn't do your homework, essentially.
Mm-hmm.
If this is, let's say, a newspaper article, and the reporter didn't call and the newspaper reported they were selling drugs, and the reporter never bothered to call the restaurant, that would probably be an example of negligence. When you're dealing with people, public officials, elected officials, celebrities, public figures, the standard is much higher. It's much harder for those people to win in defamation cases, part of the theory being that those people have access to the media, have the ability to defend themselves, as well as wanting kind of a societal desire to allow people to talk about public people like that. And so the standard is much higher. Proving that someone was negligent is not enough to meet the test for fault. You have to prove that the person essentially knew what they were saying was false.
Is there a time period within which, once this has been posted on Yelp, that the owner needs to bring a lawsuit? Is it a year or 2 years or 3 years?
Yeah, well, it varies. First of all, defamation is basically state law. It is driven by state law. So each state has different laws about these sorts of things. The law generally about defamation is pretty much the same across the states, but things like statute of limitations, when you have to bring the case, can vary anywhere from like a year to 3 years, depending on which state you're in. In Maryland, the statute of limitations is 1 year from publication, although Maryland also, there have been cases suggesting they have a discovery rule that the 1 year may not start running until you actually knew about the defamation or had reason to know about the defamation, the publication, the dissemination, if you will. However, Maryland also has another claim called false light invasion of privacy, which is very similar to defamation. That has a 3-year statute of limitations. Most claims in Maryland have 3-year statute of limitations. So it's possible in Maryland to bring it within 3 years in most cases.
Let's look at another example, which is the doctor. All doctors now, if you look up a doctor, you're going to find all kinds of ratings about that doctor. I think health grades and various other forums that grade doctors. Let's assume I go to the doctor, I have a bad experience, I go back and I go on to health grades, for example, and I post, this doctor's a quack, he doesn't know his elbow from his knee, all right? And that doctor comes to you, David, and goes, what do? I don't want this out there, and I want to take action against whomever this was. First of all, it's an anonymous review, so I don't know who did it. So how do we find out who did it? And if we do, what can I do about it?
Okay, and those are both two very difficult things to deal with, two very different issues. When you're dealing with anonymous speech, one of the biggest challenges is you may not know who the person is, and trying to figure out who that person is, who you're going to sue. If you had a good case, I'm not sure that would be a good case, but let's say it was, how to figure out who the defendant is can be most of the battle, because if they don't have their name up there, you could go to health grades and say, hey, I've been defamed, who is this? In most cases, a lot of those websites, because they want to encourage speech, they want to protect their participants, they want to promote anonymous speech, which is generally protected by the First Amendment, they're not going to tell you without a subpoena. And they may not even know. Someone may have registered using a false name. So it essentially requires you to go through this whole chain of events through using subpoenas to maybe the website operator. The website operator may only have an IP address. Then you may have to trace it back to the internet service provider. And the internet service provider will say, okay, on that day, that IP address corresponded to a Starbucks, in downtown Washington. Well, then you might have to go to the Starbucks and say, do you have a record of who was using your Wi-Fi? So it can be very challenging.
Yeah, and just to expand on that, in order to get the subpoena that he's talking about, you would have to file a legal action first.
In most cases, in most states, in Maryland.
In Maryland, you would. And this goes to actually the Maryland Court of Appeals, the highest court in Maryland, ruled in 2009, I believe, on a case dealing just with this issue. And
what was the name of that case?
It's the Independent Newspapers v. Brody case.
And who was the lawyer on that case?
Well, we represented independent newspapers,
All right.
and we did not represent the anonymous posters. But we were able to get the newspaper out. It was a case involving comments that were posted on a website, and actually some of the comments were about a Dunkin' Donuts, and the owner of the Dunkin' Donuts sued because the comments, I think, this was the dirtiest restaurant or food service place that this person had ever seen. I think that was one of the comments. Or there's trash outside and it was wafting into the river behind the restaurant. And the owner sued, and we represented the newspaper that operated the website, and we invoked Section 230, and they were dismissed. However, when the judge dismissed them, he ordered the newspaper to identify the posters.
Okay.
And so at the time, the newspaper was technically out of the case, but I talked with the editor of the newspaper, and she felt that it was not really fair because she didn't believe that this was a strong defamation action, and we agreed because we thought it was opinion that these people had posted. And so she authorized us to fight the subpoenas on behalf of the John Does. We enlisted the help of Public Citizen, which is a public interest group that's very interested in this issue of anonymous speech. And we appealed the judge's ruling all the way to the Maryland Court of Appeals, and they came up with basically a 5-step process for a plaintiff in this type of case to obtain the subpoena to identify the sources.
And let's assume in this instance they obtain the subpoena, they identify the source, and that source was sued, and we just got about a minute, and they've come to you. But the statement is simply, he's a quack, he doesn't know his elbow from his knee. Is one of the defenses to that going to be, that's really not a statement of fact, it's a little bit hyperbolic, it's not actionable?
Absolutely.
Okay.
Absolutely.
And context is important too. You're talking about a website where people are expressing opinions. There's a lot more latitude given in those sorts of situations.
And I would say it's a little different situation with doctors, because if this were some other business owner, I would certainly encourage them to go and address that comment directly and say, well, this person asked for these services and we did this and this is what we did. Make a defense. This is the marketplace of ideas. This is where free speech really comes into play. And doctors, though, are a little bit handicapped to the extent that there are HIPAA regulations, privacy regulations, so they can't disclose what went on with the patient and so forth. But there are some ways for doctors to deal with it by reaching out to the patient privately, because usually they can tell who that patient is, even if it's posted anonymously. They could try to figure that out.
So if there's some takeaways, one takeaway with respect to online posting, blogs, websites, Facebook, Twitter, whatever, just because they can't see who you are doesn't mean that you can't get in trouble for defamation. Is that correct?
Absolutely.
That people who are posting online need to be careful and be aware of these various requirements, correct? And that if such
The flip side of it is true also, that there tends to be a kernel of truth in most of these comments. So if you're the target, you need to deal with that also.
well, I want to thank you too. And there is obviously much more that we can talk about with respect to online defamation, but we've run out of time on today's show. I'd like to thank both our guests, David Watkin and Mark, for being with us. Please let us know what you think about the show, as well as any other topics that you would like to see on future shows, by emailing us at lawschoolforthepublic@gmail.com. And you can find this show and past shows online by searching Law School for the Public Montgomery and following the link. Please join us for future shows in our Law School for the Public series. On behalf of the Bar Association of Montgomery County, my name is Mark Gilday, and I thank you for watching. I'd like to thank again David and Mark for joining us today.
Great to be here.
Thank you.